Breaking news. The Supreme Court of the United States has issued a 6-3 emergency ruling overnight that significantly changes how federal power is exercised and how individual rights are enforced. The decision was released without public oral argument and is set to take effect as soon as next month. According to court documents, the ruling does not address a narrow legal dispute. Instead, it restructures the balance of authority between the judiciary, the executive branch, and federal agencies, altering how constitutional challenges are reviewed nationwide. State governments, federal agencies, and lower courts are already assessing the impact. Legal experts say the ruling represents a major shift in the enforcement of rights and will have immediate consequences across the country.
Before most Americans even opened their phones this morning, the Supreme Court quietly rewired how power actually functions in the United States. No buildup, no oral arguments broadcast on cable news, no months-long public debate. Just a sudden 6-3 emergency ruling issued in the dark hours that will begin affecting millions of people as soon as next month. And here's the part almost no one is explaining yet. This decision doesn't just tweak a policy or resolve a narrow dispute. It fundamentally alters how your rights are enforced in this country. Whether you feel it today or not, the legal ground under your feet shifted overnight. This isn't just another Supreme Court headline that flashes and disappears. This is a structural realignment of power between judges, presidents, and ordinary Americans. In state capitals, federal agencies, and courtrooms from Washington, D.C. to California, the rules that governed constitutional challenges for decades were rewritten in a matter of hours, and most people still have no idea it even happened. Before we break down why legal experts are already calling this one of the most consequential emergency rulings in modern history, make sure you're subscribed, because this is exactly the kind of Supreme Court decision that doesn't feel real until it lands directly in your life. Late last night, the Supreme Court issued a 6-3 emergency ruling in Trump v. Casa, Inc. Through what's known as the shadow docket. That means no full briefing, no public oral arguments, no extended deliberation process, just a rapid decision with immediate legal force. The case on its face involved a high-stakes executive action tied to birthright citizenship. But the court used this vehicle to resolve something much larger, a decades-long internal war over judicial authority that has been quietly building inside the federal court system. At the center of this ruling is a legal concept most Americans have never heard of, but have relied on for decades without realizing it: nationwide injunctions. The Supreme Court has now ruled that federal judges may no longer issue universal injunctions that block a law or policy from being enforced across the entire country. And while that may sound like technical courtroom language, the consequences are enormous. For the past 25 years, when someone challenged a law they believed was unconstitutional, a single federal judge could temporarily stop that law from being enforced anywhere in the United States while the case worked its way through the courts. One judge, one courtroom, one order, and the entire federal government had to pause nationwide. That power has been used repeatedly in immigration disputes, healthcare cases, environmental regulations, gun laws, workplace protections, and voting rules. A judge in California could halt a policy in Texas. A judge in Texas could block a rule from taking effect in New York. That system is now gone. The Supreme Court didn't narrow that authority, it eliminated it. According to court filings reviewed this morning, there are currently 68 active nationwide injunctions affecting everything from prescription drug access to workplace safety standards and election administration. Under this new framework, many of those injunctions could unravel within the next 60 to 90 days as lower courts are forced to rewrite their orders or dissolve them entirely. And the timing could not be more volatile. The country is heading straight into a heated election cycle with major legal battles already underway over immigration enforcement, healthcare access, civil rights protections, and voting procedures. This single ruling just changed how every one of those fights will be waged. Majority opinion was written by Justice Amy Coney Barrett and joined by Chief Justice Roberts along with Justice Alito, Gorsuch, Kavanaugh, and Thomas. Their reasoning rests on a deceptively simple claim. The Judiciary Act of 1789 they argue, never gave federal judges authority to protect people who are not actual parties to a lawsuit. According to the majority, the role of a judge is to resolve specific disputes between specific litigants, not to act as a nationwide veto over presidential or congressional action. But the most consequential reasoning didn't come from the main opinion. It came from Justice Gorsuch's concurring opinion. He traced court practice from the founding era through the late 19th century and reached a stark conclusion. American courts historically refused to issue injunctions that protected people who were not directly before the court. Judges repeatedly declined to extend relief beyond the plaintiff standing in front of them. Justice Thomas pushed the argument even further. He called nationwide injunctions a modern invention that encourages forum shopping, allowing advocacy groups to hunt for sympathetic judges to shut down policies they oppose. Nationwide, according to the majority, that entire era of judicial power has now officially ended. The dissenting justices saw the ruling as something far more dangerous. Led by Justice Sotomayor, they warned that stripping courts of universal relief gives the executive branch room to enforce unconstitutional policies while individual lawsuits slowly crawl through the system. They argued that this decision risks turning constitutional rights into privileges available only to those with the resources, time, and money to sue. And that's where part one ends, because the real impact of this ruling isn't theoretical. It's already unfolding right now across immigration enforcement, gun regulations, healthcare access, elections, and the economy itself. Within 48 hours of the ruling, the legal system began reacting in ways that make clear just how destabilizing this decision really is. State attorneys general across the country moved almost immediately. 18 states filed emergency motions in federal courts, some attempting to preserve existing injunctions before they collapse, others racing to enforce laws that had been frozen for years. Texas moved first, filing to narrow injunctions blocking aggressive immigration enforcement. Florida followed with filings aimed at reviving stalled election and social media regulations. California and New York countered with their own emergency briefs, trying to keep nationwide blocks in place on federal policies they view as unlawful. Behind the scenes, the Department of Justice convened emergency strategy calls involving hundreds of federal attorneys spread across dozens of active cases. According to officials familiar with those discussions, agencies were told to prepare for laws they believed were blocked to suddenly take effect, possibly within weeks. That includes regulations touching immigration processing, environmental enforcement, labor rules, and healthcare oversight. The speed of that response tells you everything. Legal strategists immediately recognized this ruling as a massive shift of power toward the executive branch and a severe blow to judicial resistance. Advocacy organizations are now scrambling to adapt. Groups across the ideological spectrum, from the ACLU and NAACP to conservative legal organizations, relied on nationwide injunctions as their most effective tool. That tool is now gone. Major law firms are warning clients that constitutional litigation could become exponentially more expensive. Instead of one lawsuit stopping a policy nationwide, plaintiffs may now need to file cases in dozens of jurisdictions to achieve similar protection. Some estimates suggest the cost of large-scale civil rights litigation could increase 5 to 8-fold. This is where the ruling becomes deeply personal. Immigration enforcement is ground zero. There are currently 19 injunctions limiting ICE practices nationwide. Under the new framework, those protections may now apply only to specific plaintiffs in specific districts. Immigration enforcement could look radically different depending on where you live. The same federal law enforced one way in California, another way in Texas, and a third way somewhere else entirely. The same logic applies to gun laws, healthcare access, environmental protections, workplace safety rules, and voting procedures. Your rights may now depend less on the Constitution and more on your zip code. We are entering a reality where federal law exists on paper, but is enforced unevenly across the country. One Constitution, but fragmented protection. As the nation moves toward the 2026 election cycle, this ruling sets the stage for unprecedented legal confusion. Election administrators are already warning of a nightmare scenario where voting rules vary not by state law, but by court geography. A federal election could be conducted under different legal standards depending on which district a voter lives in, not because Congress changed the law, but because courts can no longer freeze unconstitutional rules nationwide. Corporate America is also sounding the alarm. Multi-state companies now face the prospect of complying with different federal rules in different regions. Banking, healthcare, technology, manufacturing, and pharmaceuticals are all warning of massive compliance costs and regulatory uncertainty. Industry analysts estimate that this kind of legal fragmentation could cost businesses tens of billions of dollars annually, costs that will ultimately be passed on to consumers. This story goes deeper than economics. This ruling is part of a broader shift in how the Supreme Court exercises power. By relying increasingly on the shadow docket, the court is reshaping the law through emergency orders rather than full, transparent opinions. High-impact decisions are being made without oral arguments, without public deliberation, and often without clear guidance to lower courts. Critics warn this creates a chilling effect where judges hesitate to block even clearly unconstitutional actions for fear of swift reversal. For civil rights, the implications are profound. Broad injunctions were one of the primary tools used to dismantle systemic discrimination. Now, courts may only protect the few individuals who sue, leaving thousands of others exposed unless they file their own cases. Justice Jackson described this as an existential threat to the rule of law, warning that it creates zones where constitutional protections exist in theory, but not in practice. The Supreme Court's 6-3 emergency ruling in Trump v. Casa, Inc. didn't just alter a procedural rule, it changed the meaning of protection in America. If your right to vote, to equal protection, or to due process only exists when you personally have the resources to sue, then those rights begin to look less like guarantees and more like privileges. We are entering a new era of American law. Whether this represents a return to constitutional originalism or a dangerous fragmentation of justice depends on your perspective. But one thing is already clear. The legal patchwork is here, and its consequences will define immigration policy, elections, civil rights, and economic stability for years to come. And the most unsettling part is this. The shift didn't happen after months of debate. It didn't happen after voters weighed in. It happened quietly, overnight, while most of the country slept. To understand how sweeping this change really is, you have to look at what nationwide injunctions actually did in practice. They weren't just legal technicalities. They were the brake pedal on federal power. When an administration pushed a policy that courts believed violated the Constitution, one judge could stop the damage while the system worked itself out. That pause mattered. It prevented harm from spreading before higher courts had time to review the case. It gave people breathing room. And it gave the Constitution teeth. That safeguard is now gone. Under the new framework, unconstitutional policies can move forward everywhere except where a specific plaintiff has sued and won relief. That means the government can knowingly enforce a rule that a judge has already ruled unconstitutional, so long as it's enforced against people who are not parties to that lawsuit. In practical terms, the same policy can be illegal in one district and fully enforced in the next. This is where the dissent's warning becomes chillingly concrete. Justice Sotomayor didn't just argue that this weakens judicial power. She argued that it fundamentally alters the nature of constitutional rights. Rights are supposed to constrain government action across the board. But after this ruling, constitutional protections function more like individualized exemptions. You are protected only if you sue, only if you win, and only within the geographic reach of that court. That reality changes who actually benefits from constitutional law. Wealthy individuals, large corporations, and well-funded organizations can afford to file repeated lawsuits across multiple jurisdictions. Ordinary people cannot. Immigrants, low-income workers, disabled individuals and marginalized communities are now far less likely to see meaningful protection unless an advocacy group steps in on their behalf. Even then, relief will be partial and uneven. Legal scholars are already calling this a return to pre-civil rights era enforcement. Before nationwide injunctions became common, unconstitutional laws often remained in effect for years, sometimes decades, while cases crawled through the courts. During that time, real people suffered real harm. This ruling resurrects that model, and the executive branch knows it. According to officials familiar with internal discussions, federal agencies are already mapping where enforcement can resume immediately and where they need to tread more carefully. Policies that were effectively dead for years may now come roaring back, not because they were upheld on the merits, but because courts no longer have the power to stop them broadly. Enforcement will be strategic, targeted, and uneven by design. This creates a perverse incentive structure. If an administration believes a policy is legally vulnerable, it no longer needs to worry about a single judge shutting it down nationwide. It can enforce aggressively in districts where challenges are unlikely, slow, or expensive. By the time appellate courts weigh in, the policy may have already reshaped lives, markets, and institutions. Election law experts are particularly alarmed. Voting rights cases often rely on nationwide or statewide injunctions to prevent discriminatory rules from taking effect before an election. Under this new regime, a voting rule could be blocked in one district but enforced in another within the same state during the same election cycle. The potential for confusion, unequal access, and litigation chaos is enormous. And once ballots are cast, courts are historically reluctant to undo elections. That means even temporary enforcement of unconstitutional rules can have permanent consequences. This is why so many legal observers describe this ruling not as neutral procedural housekeeping, but as a power transfer. Authority shifts away from lower courts and toward whoever controls the executive branch at any given moment. The judiciary becomes reactive rather than preventative. Harm is addressed only after it occurs, not before. Supporters of the ruling argue this restores proper limits on judicial overreach. They claim nationwide injunctions allowed a single judge to hijack national policy. And there is truth to the concern about forum shopping. But the solution the court chose doesn't fine-tune that power. It eliminates it entirely. What replaces it is fragmentation. 50 states, 94 federal districts, hundreds of different interpretations of the same federal law operating at the same time. This is not stability. It is legal whiplash. And the most consequential effects may not show up immediately. They will surface gradually as agencies test boundaries, as courts issue conflicting rulings, and as people discover that their constitutional protections depend less on what the Constitution says and more on where they happen to live. That is the quiet revolution this ruling set in motion. No marches, no press conferences, no warning. The long-term consequences of this ruling are only now beginning to come into focus, and they extend far beyond any single administration or political moment. This decision doesn't just affect what happens next year or even next decade. It restructures how power flows through the American system permanently. Once nationwide injunctions are gone, they are not easily replaced. Congress would have to act, and there is no political consensus to do so. That means this framework is likely to define American law for a generation. Lower court judges are already signaling uncertainty. Some are asking whether they can still issue relief that applies statewide. Others are questioning whether class actions can be used as a workaround to approximate nationwide protection. Appellate courts are split on how far lower courts can go without violating the Supreme Court's directive. That confusion alone guarantees years of litigation before a new equilibrium is reached. And during that time, enforcement gaps will widen. What makes this especially dangerous is that it encourages aggressive behavior by future presidents of either party. If an administration knows that the worst legal consequence of an unconstitutional policy is a narrow injunction affecting only a handful of plaintiffs, the incentive to push legal boundaries skyrockets. The cost of losing in court goes down. The reward for acting first goes up. That is a recipe for executive overreach, regardless of ideology. This is why some constitutional scholars are calling this the end of preventive justice. Courts no longer stop harm before it spreads. They respond after the damage is done. And once harm is done, courts are limited in what they can undo. Deportations happen, elections pass, businesses collapse, rights are violated, and later rulings cannot fully reverse those outcomes. The irony is that this ruling was justified in the name of judicial restraint, but the practical effect may be the opposite. By forcing litigants to file case after case across the country, courts will be flooded with repetitive lawsuits raising identical constitutional questions. Instead of one judge issuing a nationwide pause, dozens of judges will be forced to rule on the same issue simultaneously. That is not efficiency. That is systemic overload. Meanwhile, ordinary Americans are left navigating a legal landscape that feels arbitrary. A policy may be illegal in one district and enforced aggressively in another. Two families living a few miles apart could be subject to completely different federal rules. The Constitution is supposed to be uniform. This ruling fractures that uniformity. And this brings us to the core question that history will ask. Did the court restore constitutional order, or did it hollow it out? Supporters will argue that judges were never meant to wield nationwide power. Critics will respond that rights without remedies are not rights at all. Both sides will cite history. Both sides will claim legitimacy, but the lived reality will be shaped not by theory, but by enforcement. What is certain is this: the Supreme Court has made itself the final and only backstop against unconstitutional federal action. Lower courts can no longer act decisively to protect broad classes of people. That concentrates enormous power at the top. And when that top court chooses to act through emergency orders rather than full opinions, transparency suffers. This is not a normal evolution of law. It is a rupture. The ruling in Trump v. Casa Inc. will not be remembered simply as a case about injunctions. It will be remembered as the moment the judiciary changed how protection works in America, where rights became conditional, where geography mattered more than principle, where power moved faster than accountability. And the most sobering part is this: nothing about this ruling guarantees better outcomes. It guarantees faster enforcement, uneven protection, and prolonged legal conflict. Whether that leads to stability or chaos depends entirely on how much restraint future leaders choose to exercise. History suggests restraint is rarely permanent. So when people ask why this decision matters, why a procedural ruling deserves this much attention, this is the answer. Because it doesn't just decide cases, it decides who must endure harm before the law catches up. And in that gap between enforcement and accountability, real lives are changed forever. That is the legacy now being written.